Hey everyone, this is Laura.
And Jess.
And Eva.
So, this is just a quick heads up. So, we're students, not legal professionals. This podcast is all about discussing interesting law cases, judgments, and sharing our own opinions.
Everything we talk about is for learning and entertainment purposes only, so please don't take it as legal advice or use it as an official source.
Always double check facts and refer to credible legal materials if you're researching or studying a case.
Thank you so much, and I hope you enjoy the episode.
So, to kickstart our podcast, we are going to be talking about the extremely famous case of Donoghue against Stevenson, 1932 AC 562, meaning it was issued in the appeal cases and it begins on page 562.
Okay, so for the facts of this case, Miss May Donoghue was sat in a cafe in Paisley, Scotland, along with her friend in August 1928. She ordered a ginger beer float, and the ginger beer itself was manufactured by David Stevenson. She drank the bottle that her friend purchased for her at the cafe, and she later discovered a decomposed snail inside. She became ill with shock and gastroenteritis, and because the bottle was opaque, she could not see the contamination until part of the contents was consumed. Furthermore, she had no reason to suspect that the bottle didn't strictly contain ginger beer. Her friend proceeded to pour the remainder of the liquid, which uncovered that there were remainders of a decomposing snail. Donoghue had not purchased the drink herself, so therefore she could not sue the cafe owner. Instead, she decided to bring a case against the manufacturer Stevenson for negligence, claiming that he had a duty of care to her as the end consumer to ensure the product was safe.
I think it's just worth noting at this point how much more straightforward, like how key it is the fact that she was not a party to this contract. This case I think would have been settled much quicker and in a much easier fashion had she bought the drink herself. Because it raised all sorts of questions about proximity and just the fact she wasn't a contracting party really.
Thus, the central question of this case, we can say that was whether Stevenson, the manufacturer, had a duty of care towards Miss Donoghue, despite her not purchasing the drink directly. So we will proceed on to the judgment.
Yeah, so we're going to talk about we're going to just talk about the key judgments. I'd say the most important judgments were given by Lord Atkin and by Lord Buckmaster, the former being the leading judgment and the latter being the dissenting judgment. So it was decided in the appeal court at the 5 judges. It was a 3-2 majority in favour of Miss Donoghue in the end, and so I think we should
winning money from the case, didn't she?
Yeah, she
won
really did. Yeah,
£200.
Absolutely went her way. Good for her.
Which was great. And nowadays that'd be like 12 grand, which is great for her.
That is great for her.
Yeah, I know. Pretty successful in the end.
Mm-hmm.
So I think should we begin with
Lord Atkin
in her favour? Yeah, we should. To begin with, I think it's worth noting that Lord Atkin, quote unquote, said, "I speak with little authority on this point, but my own research, such as it satisfies me that the principle of law of Scotland on such a question as the present," which Laura mentioned earlier, "are identical with those of English law, and I discussed the issue on that footing." So that's just extremely important to highlight early on, that Lord Atkin's judgment was based off of the English law of tort. Just, I think, purely off the basis that we don't really have any existing case law or legislation on the matter in Scots law. So I think that's worth keeping in mind. So he began with saying the law of both countries appears to be that in order to support an action for damages for negligence, which is exactly what Miss Donoghue was seeking to achieve, the complainer has to show that he has been injured by breach of a duty owed to him in the circumstances.
So within Lord Atkin's judgment, he was kind of the judge that formulated the neighbour principle, which is the main thing that comes out of this case and is going to be the main issue that we'll kind of talk about. And to quote him, he basically said, but acts or omissions which any moral code would censor cannot in a practical world be treated so as to give a right to every person injured by them to demand relief. In this way, rules of law arise which limit the range of complainants and the extent of their remedy. So basically, he formulated what became known as the neighbour principle, which forms the basis of the modern duty of care test in negligence. And the question arises, who is a neighbour in law? And in this issue, it was argued whether a manufacturer of products intended for human consumption owes a duty of care to the consumer. He kind of talks about how the consumer cannot inspect a sealed bottle that is opaque in this case. So Miss Donoghue could not have able to tell that there was a snail inside this bottle. And so they reasonably rely on the manufacturer to ensure their safety. So Miss Donoghue is relying on the manufacturer of this ginger beer to say that there wouldn't be a dead snail in her drink.
As you would.
As we would all hope would happen when you're drinking something.
Absolutely.
And harm to the consumer was reasonably foreseeable if the product contained defects like this. So under this definition of Lord Atkin's neighbour principle, like Stevenson, the manufacturer, did in fact owe a duty of care to Miss Donoghue, but this was argued later by other judges who brought up certain issues, such as Lord Buckmaster. He disagreed with the majority and argued that there was no duty of care owed by the manufacturer to the consumer. And he reasoned this on 3 key points. The first one being a lack of contract. He was emphasising that Mrs. Donoghue, as Jess mentioned earlier, she didn't have a contract with the manufacturer since the drink was bought by her friend. And this became an issue as the law of negligence traditionally developed alongside contract. And in this case, it's unclear whether there was a direct link. Secondly, there was a fear of unlimited liability. He warned that if the courts recognised a general duty of care, how far would this go? Is that kind of what he was saying?
Yeah, he kind of quote unquote had a concern of opening the floodgates. I think that was the term he used. Yeah, to what extent could we...
And how widely people would try to stretch this principle.
Exactly.
Mm-hmm. And the courts could become potentially overwhelmed by this, and too many people would be trying to sue manufacturers. But in my view, I don't know about you guys, in this case, it seems clear that a manufacturer should not allow decomposed animals to end up in drinks.
Yeah. There's definitely a duty of care here.
That is their role, and Miss Donoghue had no way of knowing that was in there without drinking it and consuming it.
I think that's such a reasonable expectation of a consumer, you know?
Exactly.
As an ordinary person. To, expect that there were like preventative measures and just like an element of care put into the packaging of your... It's obviously made for human consumption.
At the end of the day.
Ultimately, it was always made for a person to drink. And so the fact that there was a decomposing snail in this...
just seems absurd.
Bottle, it is absolutely absurd. And I personally think that the liability couldn't really lie on anyone else.
Well, yeah.
And what do you guys think of the lack of contract issue that Buckmaster brought up? The causal link between the manufacturer and Miss Donoghue?
Well, in my opinion, I don't think that anybody else could have been liable.
Yeah.
Instead of Stevenson, because it was definitely not the cafe owner, because he's not opening up every single bottle of ginger beer that he had bought from the manufacturer himself, since he is just a third party like Donoghue's friend as well.
Yeah, of course.
Because ultimately, from A to B, A being Stevenson, B being the end consumer, which is Miss Donoghue. Mm-hmm. And
I think also considering the bottle was opaque, which was ultimately a packaging decision by Stevenson, or by his company. Yeah. That almost exaggerates the responsibility of the care that you'd put into packaging your products, because they probably as a company knew fine well that each independent seller that they sell to each cafe that they sold to would not be able to intervene and assess whether the products were faulty or not.
Yeah, and there was questions of whether the decision would be different had the bottle not been opaque. Like, would there be
a huge
an expectation on Miss Donoghue to have seen a snail in her cup and then not drink it? Like, would that have changed the decision of the case? Probably.
Had the bottle been clear.
Totally.
I absolutely think it would have. Do you agree that it would have?
Yeah, what do you think, Laura?
Well, I was just going to bring it up to maybe the idea of proximity, which Lord Esher himself later discussed in Le Lièvre against Gould.
I'm glad you said that.
Yeah, I know, get the French girl to say
it. We had tried.
Because he stated that the case demonstrated that in certain situations one person may owe a duty to another, even where no contract exists between them, and if a person is in close relation to another or to that person's property, they have a responsibility to avoid actions that could cause physical harm to that individual or damage their property. So I would draw particular attention to the fact that Lord Esher emphasizes the necessity of goods having to be used immediately and used at once before a reasonable opportunity of inspection. So this is obviously to exclude the possibility of goods having their condition altered by lapse of time, and to call attention to the proximate relationship, which may be too remote, where inspection even of the person using, certainly of an intermediate person, may reasonably be interposed. Like, at the end of the day, she finished the bottle herself. It wasn't somebody else that interrupted that action. So it was from the manufacturer to the cafe, which was not, like, inspected at any point in between those.
Yep.
And then it was purchased by Donoghue's friend, which was then for immediate consumption.
So Lord Atkin wanted to draw particular attention to the fact that Lord Esher, in a previous case, it was a 1893 case of Heaven and Pender, which it was a case, just to give you brief facts of the Pender case, it was, so the owner of a dry dock was involved in a legal dispute with Heaven. So Pender is the owner. Involved in a legal dispute with Heaven, a ship painter who suffered injuries whilst using staging over the side of a ship supported by damaged ropes. The critical legal question revolved around whether Pender owed a duty of care to Heaven and others in similar circumstances. So there's some brief facts of the Heaven again and Pender case. So Lord Esher emphasised in his judgment in that case the necessity of goods having to be, open quote, used immediately, close quote, and, open quote, used at once before a reasonable opportunity of inspection, close quote. So we believe that to be extremely relevant to the case. So we're going to conclude the discussion on neighbourhood principle. We're going to revisit Lord Atkin's definition, just to make sure that it's clear to all listeners, because sometimes it's not even that clear to us. So Lord Atkin formulated the neighbourhood principle, which he defined as taking reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. And then,
so in this instance, it's the manufacturer should reasonably see that harm would have been done to Miss Donoghue.
Yeah.
So, considering they had produced a product intended for human consumption.
Exactly.
Which was
with a toxic substance.
Yeah.
Was it toxic?
Well, it ended up harming
a gross substance. It could be considered.
And
toxic.
she had to prove that she had physical harm from this.
Yeah, exactly. So Stevenson had negligently produced their own product, which could have been foreseeable, because if a snail could have entered a bottle of their own product, that means that there was a defect in their manufacturing in one way or another. So I think
did not take the reasonable steps to care for their consumers, really, is what Lord Atkin is getting at here. So he concludes his judgment.
Lord Atkin kind of concludes his judgment by stating that with the knowledge that the absence of reasonable care in the preparation or putting up of the products will result in an injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. So this just kind of sums up his entire argument and judgment of the neighbourhood principle as a whole. And this judgment was agreed with by both Lord Thankerton and Lord Macmillan. We won't go into too much detail about both of their judgments, as they mainly agree with Lord Atkin and don't add too much else.
And just for absolute clarity, Lord Atkin's judgment concludes with the fact that he would like the appeal to be allowed.
Yes.
Just in case anyone had not gathered where he stands on this. Because I feel maybe you quite easily could have gotten lost in all of in everything we've been saying. So, yeah, concludes with a very brief line. I think that this appeal should be allowed, and Lord Macmillan and Lord Thankerton's judgments are concurring with that. Just to briefly go over Lord Macmillan's judgment, he agrees with the fact that the law should evolve to cover a new situation where harm is foreseeable. He likes the idea of this evolution proposed by Lord Atkin, that this duty of care can exceed just contracting parties, and again agrees that a manufacturer who prepares good for human consumption must take reasonable care in their preparation, and just overall that negligence is a very broad legal concept. It shouldn't be confined to specific categories. It can be interpreted to adapt to different facts.
Which can be seen in like the later case law that comes from Donoghue, and there's a lot of later cases that we will go on to talk about that reference Donoghue in their judgments that aren't necessarily about manufacturers making mistakes with their products.
And I think it would be very important to mention before we get into all of this, there was a case that preceded Donoghue against Stevenson that had very similar facts.
Scarily similar facts,
actually. Might I add. So the facts of Mullen against Barr. The facts of this case were, so the Mullins discovered a dead mouse in a bottle of ginger beer, and their children were injured after drinking it. However, it failed on the grounds that there was no direct contractual relationship between the manufacturer and the consumer, of which the decision was overturned by the neighbour principle in Donoghue. And fun fact, the solicitor that represented Ms. Donoghue was Walter Leachman, that had already been involved in Mullen against Barr, which was dismissed by the Scottish courts, which stated that the defendants did not owe the claimants a duty of care. Mr. Leachman took on Mrs. Donoghue's case pro bono just 20 days after the Mullen case was handled by Mr. Leachman himself as well.
He must have been thinking, what's going on with ginger beer production at the moment?
And he was very determined.
Manufacturers making so many mistakes.
Yeah, and he was determined to, overturn that decision in Mullen.
And he did it.
And he did it. And
he got
did
this
it.
change.
Yeah. Donoghue against Stevenson was initially viewed as a food safety case, but within 5 years it was applied to many cases for suing manufacturers of products. The case founded a law of product liability, which was then recognized by courts worldwide, such as, for instance, in Australia.
Grant and Australian Knitting Mills, 1936 AC 85 is the full citation. This case concerns a doctor who lived in Adelaide, Australia in 1931, and who unfortunately suffered from dermatitis after wearing woolen underwear containing excess sulfite residue, which he had bought himself. So that's where the facts differ from Donoghue, as there is that contractual relationship present, as he bought by the consumer from the retailer. So if a garment is passed from a manufacturer to the consumer unchanged and there's a hidden defect that causes injury to the consumer can raise an action for delictual liability. This case is significant in the common law world as it followed the principles established in Donoghue and further developed the law of negligence. It dealt with a defective product, being the woolen underwear with excess sulfite residue, causing injury, being dermatitis, to the consumer, reinforcing this duty of care owed by manufacturers to the consumer. So it's really just a case which confirms Donoghue having such an impact on case law being produced in Australia. Just really highlights the extent to which jurisdictions respected this Lord Atkins judgment, and wanted to adopt his principles into their jurisdiction and their case law.
Yeah, and in that case they talk about the principles that Lord Atkin mentions about control and proximity, in relation to control being making sure the product was correctly manufactured without the defect happening in the woolen underwear, and the proximity of the manufacturer having a proximity to the consumer in the relationship between the two, being the manufacturing process. And so it just goes to show how monumental the case of Donoghue was, and the impacts that it's had, again, worldwide.
And we also have Lockhart against Barr in 1941, which, very similar as well, a woman in Fife suffered from burns to the mouth when she drank from a bottle of iron brew contaminated by phenol in 1940. However, as with Australian Knittings, the woman bought the drink herself from the retailer. So we are seeing, not only is it applied to different, like to drinks, so like goods, it is also applied to garments. And so we're kind of expanding even more this principle of neighbor and duty of care that is owed by manufacturers.
To people that can be using these products and that are really just putting their trust, their trust in the consumers. In the manufacturers, to have given them a sound product. Sound working and safe product.
Whilst we've been talking mainly about manufacturers and consumers buying products, this principle has gone even further in a slightly more recent case, Home Office and Dorset Yacht Co. 1970 AC 1004. Briefly, the facts of this case were that there were 7 boys who were in a form of young offenders institution, and they were working on an island under the supervision of 3 officers, and they ended up getting away from the officers, and they damaged the plaintiff, in this case's yacht, and the plaintiff brought an action against the Home Office for negligence from the officers, who knew of the boys' criminal records and arguably had a duty of care to the plaintiff to ensure that the boys were under proper supervision and didn't get let off. The Home Office claimed that no other person could be to blame for somebody else's crime who is of full age and capacity, so arguing that it wasn't the officer's fault or the Home Office's fault, but instead the boys who had committed this crime of damaging the yacht. But the appeal, and this was brought to an appeal, which was dismissed, and it was concluded that the Borstal officers did in fact have a duty of care to the plaintiffs. And this kind of furthers the neighbour principle and the idea of what a neighbour is in law. And it was clarified here that negligence by a third party could be similar, much like the manufacturers of the ginger beer in Donoghue, who had a duty to check that there was nothing wrong with the product. The officers in this case had a duty to make sure that the trainees were not, the trainees being the boys, were not carrying out illegal actions. And it was kind of argued in this case that it was reasonably foreseeable that there could be harm where the boys were let off, as it was known that they had criminal records and they were there to be supervised, and left unsupervised, they could potentially cause harm. And this just furthers the neighbour principle in Donoghue, and it's just a very interesting example of how far reaching this principle that Lord Atkin introduced is, as this isn't about a product. This is, and arguably the causal link between the plaintiff, whose yacht was just there around this island, and the Home Office could be seen as quite far, but it was argued that these acts are linked and that the Home Office did in fact have a duty of care.
So I think that the key takeaways to summarize this case of Donoghue against Stevenson, and its further impact, Lord Atkin's neighbour principle. A person must take reasonable care to avoid acts or omissions which one can reasonably foresee would likely injure one's neighbour, of which neighbour refers to anyone who might be closely and directly affected by one's actions, which was, in this case, any consumer of the ginger beer itself. And the House of Lords ruled in favour of Miss Donoghue and established the duty of care. So, fun facts.
I think it's fun fact time.
It's fun fact time to wrap the episode up. So, Jess, tell us
my fun fact.
I'm excited to hear your fun fact.
My fun fact, I actually learned when we studied this case in high school, and it's just stuck with me, so I hope it sticks with everyone else too. So my interesting fact is that the facts were never tested in Donoghue, so we will actually never know whether there was a decomposing snail in the ginger beer that Mrs. Donoghue consumed. I'm not sure if it's to do with the time, maybe they didn't have the resources or the desire to test whether these facts were true.
Yeah, and it was maybe more of an interest into the concept in general,
right?
Rather than about helping her.
Maybe they thought, let's just take this case by the horns and
see where it goes.
Maybe they thought this case is, even if it cannot be proven,
we want to see what would happen.
What would happen. Maybe that's exactly what they
Which
thought.
was honestly still a good decision, because this area needed to be reformed and clarified, as you spoke about in Mullen and Barr.
So even if she was a big fat liar, she did the law a favour.
And she got some money from it.
Win-win!
We love Miss Donoghue here.
And she had to declare, let's not forget that she had to declare that she was a pauper for her case to go through.
Is that what they said
Yes, she had to declare.
Is that the legal term?
Yes, she had to, oath, I am a pauper, so that she could my case is not worth, £5. I'm not £5 to the world. Yeah. There was something around, that's so sad. But
she had a really tough time getting this case through.
She had a very tough time. Yeah.
She is the instigator of the most famous Scots law case. And
we have her to thank.
And, she has a little statue commemorating her, situated in Paisley, actually.
If anyone wishes to visit her.
Yeah. Donated by the Canadian Bar
Fun fact, that's where Eva's from.
Yeah,
fun fact, that's my hometown. So let's all take a trip.
Yeah, let's go.
To go see Miss Donoghue in Paisley.
Well, just to wrap it up, Miss Donoghue did unfortunately pass away from a heart attack in 1958. She had a long-lasting influence on the law.
She did, and we all commend her for that. Yeah,
and we all really thank her for her contribution.
Her service, ultimately. Yeah, it's a service.
Hence why she has a statue for her.
Exactly. So, on that note, thank you very much for listening.
Thank you so much for listening.
We hope that this can aid your general interest in Scots law or potential study materials.
Yeah, ease your understanding on this case and the multitude of cases that we
a nice little
on the
in
many
quick succession
in here.
Yeah,
45 minutes.
Whistle-stop tour of the neighbour principle, really,
in Scots law.
But thanks for listening,
joining us,
and we hope to see you very soon for our next episode.
Bye.
Bye.